This program is a presentation of University of California Television. Your support makes UCTV's programming possible. Contribute online at uctv.tv/support. Check out our YouTube original channel, UCTV Prime, at youtube.com/UCTV Prime. Subscribe today to get new programs every week.
Welcome to What Now? Health Reform in the Aftermath of the Supreme Court Decision. My name is Daniel Doan. I'm one of the Associate Directors at the Philip R. Lee Institute for Health Policy Studies here at UCSF, and I'm going to be moderating today's panel. Yesterday, the court issued a 5-4 opinion authored by Chief Justice Roberts that upheld most of the Patient Protection and Affordable Care Act of 2010. The Affordable Care Act, also known as Obamacare, or by its initials ACA, passed in dramatic fashion in 2010. ACA is a complex piece of legislation that aims to reform both health insurance and health care delivery. The court's decision on ACA has often been cast in the context of presidential politics. Would the justices side with the Democrats or the Republicans? Does their decision represent a win for Obama or for Romney? Today, our goal is to go beyond the political scorecard. As health policy analysts, we want to delve more deeply, to understand the court's decision, and to consider how Obamacare may be implemented in light of the court's ruling. We have 4 distinguished panelists to guide us, and I'll introduce them in just a moment. But first, I want to recognize the sponsors of this event, the Philip R. Lee Institute for Health Policy Studies, the UCSF-UC Hastings Consortium on Law, Science, and Health Policy, and the UCSF Pathway to Discovery in Health and Society. I also want to thank Jessica Machado, Jay Sullivan, Ernestine Florence, and Eunice Chi from IHPS, and the UCSF Public Affairs Office for all their hard work in bringing this event to fruition. Now let me introduce our panelists and turn things over to them. Each will speak for about 10 to 15 minutes, and then we'll have plenty of time for questions and discussion. So first up is David Faigman, the John F. DeGardi Distinguished Professor of Law at UC Hastings and the Director of the UCSF-UC Hastings Consortium. David's an expert in constitutional law, and he'll help us understand the constitutional basis for the court's ruling. Jamie King is Associate Professor of Law at Hastings and the Associate Director of the Consortium. Jamie holds a PhD in health policy, and she will interpret some of the key points in the ruling and the legislation as they relate to health law and policy. Andy Beinman is Professor of Medicine, Health Policy, and Epidemiology and Biostatistics here at UCSF. Andy's one of my faculty colleagues at the Institute, and he was a Robert Wood Johnson Health Policy Fellow in the U.S. House of Representatives when the ACA was debated and passed. And he continues to travel regularly to DC to consult on its implementation. So Andy will bring an inside the Beltway perspective on the politics and policy of Obamacare. Finally, Josh Adler is Chief Medical Officer of the UCSF Medical Center and the UCSF Benioff Children's Hospital. Josh brings the perspective of a healthcare leader. He'll discuss ACA's impact for providers and systems, including how ACA may impact academic centers such as UCSF. Again, thank you all for coming, and I'm going to turn things over to David to take it.
Thank you, Dan. It's great to be here. I decided to stand up just because when you're teaching or talking about the Constitution, you ought to expand as much as you can to fill the room. First of all, it's a good day for the United States, a bad day for constitutional scholars, and I'll explain why that is the case. So the outcome is wonderful. The case itself is something of a mess. In fact, one of my constitutional law students from last year wrote me an email, and he said, "I'm very glad that I graduated this this year, so I do not have to learn the ACA case. So just in terms of constitutional doctrine, it's really an open question of where things are. At page 42 of Chief Justice Roberts' opinion for the court, he quoted a letter from Benjamin Franklin, which Franklin wrote, quote, "Our new Constitution is now established, but in this world nothing can be said to be certain except death and taxes." The short of the opinion is that the federal government has power over taxes, but not over death. So that's a takeaway line from Ben Franklin. The name of the case is actually National Federation of Independent Business versus Sebelius, although I think it'll forever be referred to as the ACA case. And in the case, as Dan pointed out, the court upheld Congress's power to impose an individual mandate, also upheld Congress's power to expand Medicaid, but subject to certain limitations. My job here today is just to kind of go through the case itself, give you the basic highlights. Many of you probably have a sense of it already, so I'll go through pretty quickly and maybe offer a few comments or maybe a few snide comments. There are three essential parts of the decision. The first essential part concerned what's called the Anti-Injunction Act. The Anti-Injunction Act was an 1867 law that provided that a tax could not be challenged until after it had gone into effect and the party that had standing had either paid or refused to pay the tax. So if that had in fact applied, the court would have dismissed the case would have been over, and it could not have come back until 2015 when you owe taxes for 2014. In short, the court held that Congress did not intend the payment, which was called a penalty in the law, in the ACA, to be treated as a tax for purposes of the Anti-Injunction Act. The Act itself describes the provision, as I said, as a penalty, not a tax. What, of course, is quite interesting, perhaps ironic, is that the Chief Justice finds later that the law is to be upheld under the Constitution as a tax, but it is not a tax, it is a penalty under the Anti-Injunction Act. So how it can be not a tax in Part 2 of the decision and it becomes a tax in Part 3 of the decision, that is the reason you go to law school. That is what you learn to sort of suffer ambiguity, and that's why my student, his name is Ryan Murphy, is glad that he is now out of law school. The second issue, the big issue, concerned the so-called individual mandate. The individual mandate had been challenged as beyond the powers of Congress to enact. In fact, Chief Justice Roberts begins his opinion. For anybody who's thinking of going to law school, I do recommend Part 1 of the decision because it's essentially a civics lesson on the relationship between the federal government and the states. The government argued principally that it had the authority under the Commerce Clause of the Constitution, buttressed by the Necessary and Proper Clause. The Commerce Clause and the Necessary and Proper Clause are both part of Article 1 of the Constitution, actually Article 1, Section 8, which describes the powers of Congress. As you all will remember, for those of you who are not lawyers, from 8th grade, that our government, our federal government, is a government of enumerated powers, and therefore the Congress has to specify where it gets its authority from. And so the federal government, referred to as the government, basically claimed that its authority came from its power to regulate interstate commerce, and the Necessary and Proper Clause actually buttresses that power, and it gives the federal government all reasonable means necessary or proper to carry out that power. Alternatively, the government argued that it had the authority to pass the individual mandate under its broad taxing power. So under Article 1, there are a list of powers like over navies and armies, commerce and coining money and so forth. But there's a separate provision that actually gives the federal government the general welfare power over taxing and spending. So this one case, it's a wonderful case for people who teach constitutional law in one sense, because it presents some of the major issues of constitutional law in the beginning, because there was a Commerce Clause problem, which is huge, but it was also a taxing and spending problem as well. We'll get to the spending when we get to the Medicaid expansion. Chief Justice Roberts found that the Commerce Power did not authorize Congress to require individuals to purchase health insurance, but that the taxing power did authorize Congress to lay and collect taxes on those who failed to purchase health insurance. Once again, and I was playing golf the other day, and somebody came up to me and said, well, explain to me how you can have the power in one area but not have the power in another area, but you're essentially doing exactly the same thing. And I again said, well, you need to go to law school to understand that. It's not that you actually understand it after you go to law school, but you're willing to suffer not understanding it. So I don't actually understand it. Chief Justice Roberts doesn't actually understand it. But as long as the system keeps moving forward, we're all more or less willing to accept it. In short, the theory of the Constitution is, as I said, the federal government is a government of enumerated powers. So the government did have to specify where it was getting its power from. Moreover, the court has to specify where it thinks the Congress gets its power from, and they relied on the taxing power. The Commerce Clause, Roberts wrote, did not give Congress the authority to create commerce, but only to regulate commerce that already exists. This argument relies in part on a somewhat technical distinction in constitutional law, which has been described as the activity-inactivity distinction, that historically Congress had the power to affect activities. In fact, the rule says that Congress has the power to regulate activities that substantially affect interstate commerce. And so the argument was that buying health insurance is or not buying health insurance is an inactivity, and Congress doesn't have the power over it. I have to say, prior to the ACA actually being passed, most constitutional law scholars thought that that was a laughable argument, this sort of Tea Party argument that activity-inactivity made a constitutional difference. Most of us would have thought it was fairly ridiculous. If one of my students had made that argument on an exam, they probably would not have done very well. But it really got traction, it got resonance, and whether it was through the megaphones of Fox News or whatever, somehow, and some constitutional scholars like Randy Barnett advocated that position. If you want a very exacting and rigorous and brilliant treatment of why that is ridiculous, you really ought to read Justice Ginsburg's concurring opinion and dissenting on the Commerce Clause issue. It may be the most brilliant opinion that she's written while she's on the court. She's written some, like United States versus Virginia, which was the VMI case. But it's really a wonderful piece of scholarship. Among many of the ironies in the case, which we can get into in the discussion, again, from a constitutional matter, Roberts takes a highly formalistic approach to the Commerce Clause. So he basically says that when you look at the specific form of the Commerce Clause, it doesn't extend to give Congress the authority over the individual mandate. Yet, under the taxing power, he adopts a different constitutional methodology, which is called a functional constitutional methodology. So in the different parts of the opinion, he's actually using two different constitutional methodologies, which again would be a red X on when I'm grading exams. So as you can see, I don't think Chief Justice Roberts, I think that the outcome was a wonderful outcome, but I think Chief Justice Roberts did not do very well in writing the opinion. Next, Roberts considered whether the taxing power provided the alternative basis, and he said that it does. He argued that unlike the Anti-Injunction Act, which is a statute, the question of whether the tax penalty provision enforcing the individual mandate was a permissible tax under the Constitution, and that that question is a constitutional question, not a statutory question. So really the difference and the explanation for why in Part 2 of the opinion it's not a tax for the Anti-Injunction Act is because it's a statutorily defined question of whether it's a tax or a penalty, but under the issue of whether the Congress has the authority under the taxing power, that's a constitutional question, not a statutory interpretation question. On the statutory interpretation question, the court is supposed to be deferential. The court's supposed to be deferential to Congress. On the question of the Constitution and the interpretation of the Constitution, the court is not supposed to be deferential to Congress. Couple of snide comments. As I said, the opinion itself is a bit of a mess. As I also said, as a constitutional matter, the opinion doesn't hold up in terms of constitutional methodologies being formalistic and then functional. And then one I might ask, how did Roberts end up writing this? I am luckily on the record for thinking that the court was going to uphold this case. In fact, I thought that Roberts would be the deciding vote. Chief Justice Roberts wrote a case called the United States versus Comstock, which many of you in the room who are in psychiatry will recognize, that upheld the Adam Walsh Act, which allowed the federal government to civilly commit former federal prisoners as sexually violent predators. Roberts read the Commerce Clause very expansively in that case. Justice Kennedy, on the other hand, which a lot of people thought that Justice Kennedy would be the swing vote, Justice Kennedy is the swing vote in lots of cases. He is not the swing vote on federal and state power. He consistently rules on the side of state power. He has a very 19th century notion regarding the relationship between federal and state power, and he's almost always on the state power side of things. The other point that I would make that is just pure speculation is that I think Chief Justice Roberts wanted to be on the right side of history. And on the issue of expansion of federal power in our highly interdependent nation, the past, at least since 1937, and the future is one of federal power. And quite frankly, I think Chief Justice Roberts was worried about his legacy. I think if he had joined the dissenters, the joint dissent, he would have been perceived, it would have become the Roberts Court, and it would have been put in the same basket as justices like Chief Justice Roger Taney, who of course decided the Dred Scott case, Justice Peckham, who decided Lochner versus New York. It would have been perceived as a purely political outcome, and I think that it would have shed really disrepute on Chief Justice Roberts' legacy. So I think that when push came to shove, there's even been some suggestion that he changed his vote in the months just prior, and that wouldn't surprise me, especially reading the joint dissent. The joint dissent is actually an interesting animal itself. Typically, justices write dissents that are joined by other justices. This was a dissent that was signed by all four of the justices in dissent. It reads like Scalia wrote it because it's extremely snarky, and so pretty sure that he wrote most of it. And he also throws out lots of Latin terms that we don't so much use anymore, except when we're around medical school audiences. So it looks like we know something. And rarely do they all sign the opinion in that way. So that's unusual. Finally, I'll finish up, and I know that my colleague Jamie King will get into this more. The final issue is the Medicaid expansion. That's a spending clause problem under constitutional precedent. The rule is, it's a case called South Dakota versus Dole, but the rule is that if the federal government commandeers the states or coerces the states to become agents of the federal government, that's unconstitutional. And there were actually 7 members of the court that found that depriving the states of all of their Medicaid funds for failure to expand Medicaid was unconstitutionally coercive and would effectively commandeer the states into the federal apparatus, and that was unconstitutional. However, they limited the reading of the statute to say that a state would forego its Medicaid money if it failed to expand, which of course we're talking about tens of millions of dollars. So every expectation is that that will still be coercive, but it will be constitutionally coercive, so that's okay. So I'll end there, and I'm more than happy to, and I look forward to answering your questions. Thank you.
Thank you, Dan, and thank you all of you for coming. This is a really exciting time in the world of health law and policy. And so what I'm going to do today is just tell you a little bit of the highlights of this case from a health law and policy angle. So as David told you, the major two findings from this case are that the individual mandate was upheld and that the Medicaid expansion provisions were limited in that it would be constitutional for the court, for the federal government to offer funding for Medicaid expansion, but not constitutional for it to restrict, to pull all the rest of Medicaid funding if a state decided not to participate. But what that means is that the major parts of the act are upheld. For those of you who don't know what this picture is, this is Obama holding up the CNN website saying that the mandate is struck down when they misreported it initially. But all the things that we have come to know and understand as a part of this act, they will all continue to go forward, and most of them in 2014, although some of them are effective now. So as far as the rest of this talk goes, what I want to do is just highlight 4 things pretty quickly for you. The first is that nearly all individuals will have to purchase health insurance starting in 2014, and we'll talk about how the case, if it all, changes the tenor of that. We'll talk about the Medicaid expansion opt-in, what's going to happen with some of the exchanges, and then future litigation and repeal efforts. So first and foremost, no broccoli horrible, right? Chief Justice Roberts' decision to uphold the mandate on the basis that the penalty for failure to comply with the mandate constitutes tax means that the deeply feared and much talked about government mandate to buy broccoli is not going to hold muster anymore. Justice Ginsburg called it the broccoli horrible repeatedly in the opinion. She's quite snarky as well to Justice Roberts at a few points in the opinion, which is great. So this will be forevermore deemed unconstitutional. So for those of you who are looking to beat obesity by forcing people to buy vegetables, it's not going to go forward. But all joking aside, I think that Roberts' opinion in holding this as a tax means that it changes the tenor of the mandate a little bit, and it draws people's attention pretty strongly to the idea that, well, yes, this is a mandate, but now it's a choice, right? You can buy health insurance, or you can choose to pay this penalty. And the penalty, the more people start to look at it, they might realize, well, that penalty really isn't that much money. It's a minimum of $95 per individual in 2014, or up to about 1% of income. It goes up to $295 in 2015, and then up to $695 at the minimum, and up to 2.5% of income. But for some people, that penalty might be significantly less than the cost of the lowest cost plan. As a result of this choice, the Congressional Budget Office estimates that about 4 million people that are currently uninsured are not going to buy health insurance. They're going to pay the penalty. And I think all the attention that has been drawn to this idea that it's a tax is going to make people more cognizant of this idea that they can bypass health insurance if they want to, if they just want to pay the penalty. The other thing that's been brought up sort of repeatedly is limited enforcement of this. The idea that, yes, it's a tax, but the IRS has limited ability to enforce it. They don't have the full panoply of options that they ordinarily have. They can't bring criminal penalties against it, and they can't levy. They can't put liens on your property for failure to pay it. They can increase the fines that you owe over time, but the more this gets talked about and touted, the more some people may decide that opting out is the way they want to go. So it doesn't really change anything with regards to the act, but it may change the way some people think about it. So let's talk now a little bit about the Medicaid expansion. As David mentioned, the court affirmed the expansion, but only in a limited way, such that states have the option to opt out. They can decide not to expand their Medicaid program to cover people up to 133% of the federal poverty level if they want to. And those are people who make about $30,000 a year for a family of 4, or about $15,000 a year for a family, for a couple, or for an individual, sorry. So this might have the ability to substantially cut into the 16 million people that currently were expected to get Medicaid under this expansion. And the court's reasoning for doing this was largely that the court felt that this was a real, not only a change in the degree of the Medicaid program, but a change in kind. And the reason that is because, or the reason that Justice Roberts said it was because historically Medicaid eligibility has been based on the idea that we want to cover not only the neediest people, not only the poorest, but the poorest within categories, right? The people who are the disabled, the blind, the elderly, and needy families with dependent children. But current Medicaid bills really don't cover that many childless adults. There's a lot of people who are left off our current Medicaid. And what he says is that the difference that this expansion makes is that it is part of a much larger, overarching program to provide universal health care, and therefore that fundamentally changes the nature of the Medicaid program. And so therefore, because it's this massive change, it can't be considered as other expansions have been considered before. It's not that we've never expanded who is eligible for Medicaid before, but that this is such a fundamental expansion that it cannot be considered in the same way that it has previously. And so as a result of that, he felt that for a lot of states, Medicaid spending accounts about 20% of their overall state funding budget. The federal government contributes about 50% of Medicaid spending, 50 to 83%, depending on the state, which is a really substantial portion of state budgets for people. And the threat of withdrawing that for states that do not expand up to to cover Medicaid for all people for 133% of the federal poverty level, is coercive. He went so far as to say it basically puts a gun to the head of these states. Now, those of you may be thinking, well, the ACA provides 100% of funding to cover these newly eligible individuals. It does for the first couple of years, but then as time goes on, it ratchets down to about 90%. Now, 90% is a lot higher percentage than the states are currently getting under their Medicaid program for the people they already cover, but it still would represent, over time, a significant amount of money for a number of states. And so what's interesting is to watch and see what people will do. What will the states do? Well, a lot of pundits have said, and I think that they are quite right, that states are going to be crazy to turn away federal money. They're going to be totally crazy. But in the initial response, we heard yesterday from Governor Scott Walker from Wisconsin, who said that he's not going to take any action on the bill with respect to Medicaid expansion or with respect to the exchanges until the elections in November, and he's hoping for a full repeal. Mississippi Lieutenant Governor Tate Reeves stated that Mississippi taxpayers cannot afford the cost of the expansion, and so it was inclined to not drastically expand Medicaid. And Florida Governor Rick Scott said yesterday that the expansion would be devastating to the state's economy. Then this morning he was quoted in the New York Times saying, well, he'd have to think about it more because potentially there might be too much money to leave on the table. And I think that's what we're going to end up seeing, is that the vast majority of states are going to look at this and realize that it's so much money and that it's 100% starting forward, and that they're going to have a hard time justifying turning people down for health insurance if they only have to pay 90%. If you currently know that all states currently participate in the Medicaid program at different funding levels. But until that time, until we have all states participating, we have a really interesting conundrum with this bill. And the reality is that the couple here on your right, they will make say they make $15,000 a year. They are below 100% of the federal poverty level. They will not be required by the mandate to have insurance, because presumably the cost of the lowest price plan will exceed 8% of their income, probably exceed most of their income. But they're also not eligible for subsidies because they make less than 100% of the federal poverty level. The subsidies, the tax credits only start at 100% of the poverty level and go to 133. So at that point, they're not going to get any help. Whereas the couple here on this side of the screen, they might make $90,000 a year and have a family of 4. They're going to get help from the federal government to buy insurance. These guys aren't. And so it's an interesting loophole that they haven't really talked about much at this point. Now, there's a couple things the federal government can do. There's a small provision that exists in the bill that says resident aliens that don't qualify for Medicaid because they haven't been in the country for 5 years yet, if they make less than 100% of the federal poverty level, the government will treat them as meeting that standard in order to give them subsidies. So the federal government might put these people in that category and just say, well, we'll just treat you like you make 100% of the federal poverty level and we'll cover you. The problem with that strategy is that the federal government is then essentially saying to the states, if you don't cover them, we will. And we'll cover them at 100%, and we'll do it going forward. Now, maybe if 2 or 3 states don't do that, that's what the federal government wants to do. But what's the incentive for the states to cover those people if they know the federal government's going to pick them up in the end? So it creates a little bit of a game of chicken between the states and the federal government about who's really going to cover these people now. Now, there may not be a lot of incentive for states to cover the poorest of the poor because they don't have a lot of political clout, but hospitals do. And what's going to happen to states is they're going to find out that their safety net hospitals are very upset about this, because this means that 16 million people who are supposed to get Medicaid are now not only not going to get Medicaid, but they're also much more likely to be uninsured, right? Because they don't get subsidies to pay for any of these bills either. And so if they don't have coverage, safety net hospitals are going to be exposed to people that have a lot greater uncompensated care. What has also happened in the ACA, though, is that disproportionate share hospital funding that goes to help fund these individuals and for uncompensated care has been cut because all these people are supposed to be on Medicaid. And so if that funding is drying up, all of a sudden, there's not a lot of funding, and this money to cover the uncompensated care for these individuals is going to end up being put back on the states. So what you might see is if hospitals can get this message out to the state legislators, you should eventually, I think, see them start taking up Medicaid. But it'll be an interesting game to sort of watch of chicken between them. So let's briefly talk about, so this is just sort of where these individuals fall. They fall in here as far as not getting covered. Okay. So let's talk a little bit about the exchanges. Another major issue for the health law is that the status of the exchanges in a lot of states. A lot of states have been sitting on their hands with the development of the exchanges and waiting to see what the outcome of this bill is. I think a lot of states were shocked at the opinion yesterday that everything got upheld. And so as a result, you've got a large number of states that have been waiting on planning. 27 states have been proceeding as though the law is going to go forward. About 5 of them have been waiting on the ruling. You've got 12 that have just halted all planning altogether, and you've got 6 that have made no significant start. All of these state exchanges have to present blueprints to the federal government about 10 days after the election in November, showing them what they're going to do with their exchange, and they have to have the full plan to them by January 1 so that the government can decide which exchanges are likely to go forward and which exchanges are not really going to make the cuts. But in order to do that, they've got to build IT systems, they've got to build a whole wealth of things in order to get that exchange off the ground. And because they've been sitting on their hands all this time, determined that this thing is going to get repealed, it's going to be a lot harder for those states to develop their own state exchange. If they can't develop their own state exchange, they're going to have a lot less power to tailor it to their needs, and their federal government will step in and run the exchange itself. So it'll be interesting to see which states try to scramble and get the exchanges going, and which states really wait for a repeal. So finally, is this the end of the fight? I don't think it is. I think that there are 4 strategies that are going to be likely to try and undermine the bill. One is wait till November and repeal and replace. You've heard that repeatedly over and over. The government might try to repeal certain portions of the bill, although when you look at a lot of the portions individually, there are huge portions of the bill that get a lot of bipartisan support, a lot of support from independents, and a lot of supports even from Republicans for a number of pieces of this bill. And so they may not be able to overturn things quite as easily on an individual piece-by-piece basis as people think. Finally, I heard some individuals talk about litigating the HHS regulations, and so you might see some fights in some cases come down about specific regulations. I don't think we'll see another wholesale litigation of the entire bill. And then finally, the fight might really come down at the congressional level at how are we going to appropriate different portions of this bill. A lot of the bill has not been appropriated fully yet, and so the fight may come to whether or not there is funding for a lot of the things that the bill wants to do and tries to do, or whether that funding is really minimal at a level that it allows it to not be effective. Okay, so those are the points that I wanted to make. In the end, thank you so much. If you are interested in these topics and the relevance of health law and intersection of health law and policy, please come to more consortium events in the future.
That was great. I think I'll make my comments from here, if that's okay. I think that was a fantastic overview of some of the stuff of the law. I'm still learning so much about the law, and I guess there's a lot to learn. What I want to do is maybe just reflect a little bit on some of the things of what I've experienced around this as a physician, a little bit involved with it, and then just lay out some of where I think we are and where we're going. And I guess if I spoke Italian and could say what the Affordable Care Act is in Italian, we'd have the title of a new opera, because I think this has had all of the elements of a fantastic opera. I mean, the twists and turns of getting this law passed and has been just extraordinary. I mean, going back to how it was initially passed, the Scott Brown change, how the House and the Senate had to reconcile their differences. And it's just has gone on and on, including, like you mentioned yesterday. I had CNN on and thought for a couple of minutes, thought it was over, right? And then, in fact, it came back again. It's like Al Pacino, right? It's like, just when you think, So it's got all these twists and turns to it that are, just extraordinary. And I actually want to reflect on that a little bit, because I had really was given a fantastic opportunity because of a fellowship of the Robert Wood Johnson Foundation that provides opportunities for mid-career health professionals to go work with members of Congress, and my timing was impeccable because I was able to show up in the fall of 2009. But what became immediately obvious to me that was so different about that world compared to my world of doctoring in the hospital is, when I sort of simplify what my life is and going on ward rounds, and, we see patient in the bed, and I turn to the residents and I say, okay, the plan today is we're going to give a little more Lasix or a little less this. And that's pretty much the end of the discussion. I mean, there might be a little feedback from the resident that said, hey, had you thought about this antibiotic or things like that? But we pretty much reached closure. And I found in my time in the Congress that it never seems to end. I mean, ever you have a discussion, you think you've got everyone on board, and there's a remarkable ability for the conversation to go on and on and on. And I mean, I continue to see that now. It was mentioned in the beginning that I've had an opportunity to continue to do some consultative work with the Secretary's office around some of the regulations and implementation, and some of the same battles that I thought had been raised and addressed and answered continue to be raised and re-raised and so forth. And even yesterday, I think you heard many who were not as happy about the decision of the Supreme Court saying, this is not over. And I'm getting the feeling it might not be, because there's just a tremendous amount of passion here. Having said that, I did feel from many friends and colleagues just an incredible outpouring of emails and phone calls and so forth. And there was a little bit of sense that I had that, this law went up against a pretty big fight in the Supreme Court, and it came out pretty much unscathed. It's sort of like, a great sports figure underdog who had to beat, a tough team or something, and won in the end. And I just have a little bit of sense that it maybe warmed the hearts of those who wanted to love this bill, maybe some of you here in the audience, a little bit more. Because, you know, there's been an ambivalent relationship around this law, maybe almost like people were afraid to embrace it because it was going to get overturned again in some ways. So anyway, I just feel like maybe a very significant turning point has happened, even though I don't think the fight is necessarily over. I do want to bring just really simplified focus to make sure we understand why the mandate was a big deal about this yesterday, and to make sure that the kind of what I think of as the triangle of what is at the heart of this bill, of this law, what was all about. And if you think about it in the following ways, which is that there was pretty broad consensus across the Congress that individuals who were sick or in need of health care were ironically the same people who were having so much difficulty getting health insurance. It just didn't seem to make sense to a lot of people. Pre-existing conditions became the barrier to getting the thing that you thought people needed. And so there was a desire to sort of say, listen, health insurance companies, this cannot go on. We need to make it so that everyone can come in. And health insurance companies said back, I don't know what the tone of their voice was or how they expressed this completely, but they said something along the lines of, well, the problem is we notice the people who come to buy our products know something about their health, and we're worried that they're the really sick ones, and so there may be a lot of costs behind those individuals stepping forward. It isn't just healthy people saying, gee, I'm being careful for a rainy day. They thought there was disproportionately sicker people coming forward. And the idea of the individual mandate was to say, you know what, let's have the same starting line for everyone. Let's get everyone into this to make sure that it isn't selection on the basis of health and that everyone would come in under this roof. So that sounded like a good thing, except people then remembered health insurance, that's a pretty expensive product. And so if we're going to force everyone to get this, we need to have a way to make sure that those who can't afford it are in fact able to do that. And what I think you just heard so eloquently described is there's basically two ways the federal government is doing this and is investing in helping people up to 400% of the federal poverty level, which is about $90,000 for a family of four, to help them buy insurance. Half of that group, essentially up to 133% of the federal poverty level, will come into the Medicaid program, notwithstanding some of the issues that were just raised about whether some states will make that harder or not, and the other half through the exchanges. And when you're in the exchange, if you're between that 133% of federal poverty and 400% of federal poverty, the government on a sliding scale basis is going to help you buy insurance. And if you're at the low end of that income sliding scale, they're going to pay almost all of it, right? So they're going to help very low income people buy private insurance to come in. But even up toward $90,000, there'll be a little bit provided to help people to make this more affordable. So that's the three pieces that had to come together. And without the mandate, there was, of course, the fear that if it didn't require everyone to get insurance, that we'd be back in that situation of only the sickest people coming forward to buy insurance, insurance companies then on a cycle of continually raising the prices, and as the price goes up, the healthier people dropping off. This was known as the death spiral, if you will, of health insurance. And so that's why the individual mandate makes sure that we all stay in the pool together. So that was a critical part of the decision yesterday and why it was so conceptually important. Now, in terms of what happens next, what mostly the discussion has been about a coverage expansion. And in fact, the Affordable Care Act, in its the main parts of it are about coverage expansion. It does also address a number of things about the delivery system that we can talk about today as well, things like accountable care organizations, primary care medical homes, new ways of paying providers to bundle payments together in ways that will try to promote more efficient ways of delivering care. But really the majority of this legislation is about expanding coverage. And if it's fully implemented and working as planned, we will be up around 94 or 95% of our population covered through either their current coverage and then how it will be expanded to cover them. But what we care about most is not just getting people health insurance cards. We want people who need to be able to go to the doctor, who need to come to hospitals, who need to be in nursing homes, who need different parts of the health system to be able to take advantage of those. So it's about turning coverage coverage into access. And this is, in fact, where we are right now. We got the check mark yesterday to continue to proceed forward with the coverage expansion, but we still have a lot to do to make sure that we can get this thing implemented in a way that will expand access. And for all of you in the audience who want to roll up your sleeves and get involved, the ACA is not self-implementing. Everyone needs to get involved. This is that there's a lot of things that have to happen. And just to sort of give some examples of that, there's very complicated issues that the state is currently working on between the exchange and the Medicaid program, so that when individuals come forward and say, hey, I heard the government said I need to get insurance, which door do I go in? And the idea is to create no wrong door, so that we can figure out on one simplified way what your income qualifications are. Do you end up going into the Medicaid pool? Do you end up going into the exchange? How much money will you get from the federal government to help you buy insurance, and so forth? And so that's a big IT program that's underway, with the idea of really trying to simplify that so that people can come in and get that coverage. But then once they have that coverage, where are they going to go to get care? We start off in California right now, as is true in many parts of the country. We have been facing a declining interest in fields like primary care, or the front line of getting people into health care. And so we need to make sure there are going to be doctors available to take care of many people who have probably put off taking care of their health problems for many years, right? If you had financial barriers, you probably let some problems wait on the side so that you could continue to buy food or other key essentials in your life. Now, if you have health care coverage, this is the time that individuals will show up at doctor's offices, and so this could, in fact, increase some demand on primary care and other parts of the system. And so it's critical that there be in place enough providers, and that's going to vary tremendously by region. We do know this. We are blessed here in San Francisco in many ways of having a good number of physicians and other health professionals, fantastic hospitals like UCSF Medical Center and so forth. But many parts of this state, the places in this state where the majority of people are going to come into coverage, places like the Central Valley of California, are the exact same places where there are real shortages of primary care and specialist physicians. And so we really need to think about how we promote getting providers to be in those places and to provide care efficiently, so that the coverage truly turns into an access expansion. And the state has a role to play in this. I mean, part of the reason, for example, that the Medicaid program, which is a real foundation piece of this expansion, does not have the full participation of physicians and hospitals throughout our state, is because California has made choices about paying its providers relatively low rates. In fact, the state of California is among the very lowest payers in the Medicaid program, in the Medi-Cal program. And this, in fact, dissuades many providers from participating in the program. There is a provision in the Affordable Care Act that will require the state to pay 100% Medicare rates to primary care physicians in 2013 and 14 to try to encourage them to expand their capacity to take on Medicaid patients. But we need to do even more than this to make sure that we're going to have adequate capacity. And let's not forget that the ACA is not the only stressor on the needs that we have for health care. Our population continues to age, and as a result, there's more need evolving and developing in our population. And clearly, we need to invest in more efficient ways of delivering care and focusing on preventive care to try to, in fact, reduce the demand for a treatment of chronic illness and the like. So I want to just, I guess, stop at my comments and say a shriek of hallelujah. I think this is a tremendous step forward. I'm very excited that we live another day to be able to continue the discussions about how to implement this successfully. I'm very thankful that I live and work in the state of California, which has been extremely proactive in moving ahead and trying to implement this, had the courage to say from day one it was going to try to set up its exchange, has worked through other Medicaid waiver programs with the federal government to get resources to help public hospitals and the UC hospitals to have some additional resources to prepare for expanding capacity, and working on improving its efficiency and delivery, and I'm sure my colleague, Dr. Adler, will have some comments to say about that. But this is a great opportunity in front of us. We've been given the life to go on with it, and I just hope that as many of you as possible are able to contribute in the process. This is a real opportunity to send a message of equity and social justice throughout our population, and making sure that health care is a right and that everyone is given the best chance to have the best health to pursue liberty and happiness and all those wonderful things in America. Thank you.
Well, thank you very much, and so glad so many people came out, and Dan organized such a terrific session with absolutely impeccable timing, I have to say, Dan. Now, I don't know what it means that the attorneys stood in front of you to speak, and the two doctors are sitting on our butts, but so be it. So just by way of introduction, I agree with my colleagues that this is a terrifically successful week in America, and particularly for American healthcare. It seems to me there's no bigger black mark on American healthcare than the fact that we've had somewhere between 30 and 40 or 50 million Americans with very, very poor or no access. And so that is a problem that is at least substantially solved by passage of this act. But I would like to make a few specific comments getting more into the realm of delivery and the delivery system, and I'll pick up on some of the things that Andy said. So clearly, many more patients will have insurance. That is a good thing for the delivery system because the delivery system is trying to deliver care, and we can do a better job when there's at least a little bit of cash available to do it. In particular, this is particularly important for the so-called public hospitals. And in California, the 22 public hospitals take care of more than half of all uninsured people in California. So this is an extremely important legislation to help public hospitals go about their mission. But in addition to just having insurance, one of the other great benefits, I believe, is the fact that this probably increases the durability of insurance. In the delivery system, providing care to people that have unstable states of insurance is very, very challenging. And this is not just people in the Medicaid program and Medi-Cal program who are constantly going on and off the rolls based on very small changes in income or assets. But people change jobs. They change roles within companies. And the fact that their insurance goes from 0 to 100% frequently makes delivering continuous care very, very difficult. And the coverage expansion and the coverage provisions of the ACA seem to provide some stabilization there. Another potential effect on the delivery system is a possible, and I use the word guardedly, a possible reduction in the cost shift. Most of you know that, for the most part, and Andy alluded to this, that the payments that come to the delivery system from Medicaid programs and Medi-Cal in California are generally not sufficient to meet the costs of the care provided. And certainly for people who are uninsured, it's insufficient, which results in delivery systems needing to shift costs from paying patients to those who are not paying. This should improve that somewhat, although I would say this is one of the great unknowns about the future, depending on the proportion of patients that enter the exchanges, what the payment rates look like from plans to providers going forward, but it certainly seems like it's in the right direction. A major challenge, as alluded to by Andy, and I won't go further, is this notion of access. We clearly have an access. We actually, in many parts of the state, already have an access challenge for primary care and specialty care. Some of it is based on the fact that low payment in the Medi-Cal program, but a lot of it is just maldistribution of providers. We have a unique opportunity in California. California has among the most restrictive scopes of services for non-physicians, whether it be psychologists, nurse practitioners, nurses, medical assistants, technicians. In order to solve this problem, we need everybody in the boat. Everybody needs to be able to practice at the top of their expertise, and we currently in California are not allowing everybody to do that. So this is perhaps a charge to the state legislature and all of us who have influence on them to look to expand the scope of service where appropriate so that everybody can practice delivery of health care to the top of their abilities and their license. Okay, so it was already alluded to, the notion of coverage expansion was the bulk of this legislation. And in fact, it's fairly lacking in its ability to drive improvements in quality and reductions in variation in care. There are modest provisions in the legislation, but they're relatively weak compared to the coverage expansion provisions. They largely rely on existing functions within the federal government and state governments to improve quality. They're pay-for-performance systems that have modest amounts of dollars at risk, public reporting systems that, interestingly enough, are only looked at by healthcare delivery systems. The general public virtually never looks at or pays attention to public reporting systems on quality and outcomes, and targeted penalties for adverse events. Part of the reason it's difficult, I think, to legislate improvements in quality is that, in truth, it is not exactly known by the delivery system how to do it. How do we actually improve the health of an entire population or of a subset of a population? I'm very hopeful that between the Affordable Care Act and the provisions in the meaningful use legislation, that at some point in the relatively near future, we will know a lot more about the state of health of Americans or the state of health of San Franciscans in order to be able to both incentivize improvement and actually deliver a better quality product from the standpoint of health care. But that will be a subsequent step. That's not in the legislation now. It will undoubtedly require further legislative action and hopefully another 5 or 10 years for Andy in Washington to make this happen. And then finally, I wanted to say a word about cost. That the thing that is most lacking in the ACA is real drivers to reduce cost. There are a few. Hospitals will get paid less for Medicare patients, and disproportionate share funds, that is the sort of additional payment that goes to take care of the uninsured, will go away. So there will be that, but that's a very modest change and pales in comparison to what we really need to do in this country to reduce costs. Some of it has to do with efficiency. Some of it has to do with not providing services that don't add value to patients and families. But a lot of it has to do with realignment of everybody's work. And there are essentially the provisions in the ACA provide some funding for experiments via the Center for Medicare and Medicaid Innovation. And there will be experiments going on, but they're not real drivers. Fortunately, those drivers are already here. The drivers that need to reduce costs are right in our community today. They're employers and patients and labor unions telling us all that we are spending too much and we need to find a way to spend less. So what I think the next phase of legislation has to be some way of crafting guidance for the best ways to reduce costs and the safest ways to reduce costs. Because if the marketplace alone will certainly force cost reductions. Some of it will be really good, and some of it may actually be potentially harmful. So what we need to do is have legislative guidance and protection so that cost reduction happens in the safest possible way. And lastly, education and research, two of our most important missions at UCSF. What effects there? Well, I certainly think in the realm of education, this notion of can we produce more providers of care, whether it's primary care providers, whether it's nurse practitioners, whether it's technicians, whether it's nurses, et cetera, I believe we will be asked to do that, to literally expand the number of workers in the healthcare system in some manner. But which workers and in what manner and how it's going to happen remains to be seen, because as Andy mentioned, this notion of maldistribution is a real problem. We keep producing healthcare providers who keep staying in San Francisco. That actually doesn't help most of California. And research, I think there is an important call for research, because none of us really know what the effects of these changes will mean for the health of populations, whether it's the entirety of the United States or small populations within communities. we don't really have the data systems and the collection mechanisms to understand how to rapidly assess the effect of these changes on the health of populations, but we need to develop them. And I think we at UCSF, as well as other academic institutions, have to take on that responsibility to be able to rapidly understand what has happened to this population in the last 6 months. Are they better or worse? So I think there's a lot to do. This is a great opportunity, but it's really only the beginning of what's likely to be a very long journey. So thank you very much, and we look forward to your questions.
So thank you for a wonderful panel. I think I've certainly learned something about snarky justices, about the fact that the ACA is not going to be self-implementing, which I actually kind of thought it was. And I think in Jamie and Josh's comments, we've heard of the call and the need for more health policy researchers and more health policy research. So I know you all have a lot of questions.
I mean, I do want to first underscore something you said, which may not be fully appreciated by everyone here, which is that there are actually many people today in California and around the country who are actually eligible for some programs as they exist today, before the Affordable Care Act even passed. So there are clearly barriers that have made it hard for people to know that they are either eligible for health insurance and don't have it, or that there are barriers that make it difficult to either get it or maintain it and so forth. And if you, I mean, just to talk about it in simple terms for the Medicaid program, you can imagine that if the program is being administered by the state, and the state knows that if it does a really good job of finding everyone, that, by the way, it has to spend more money because it now is responsible for signing people up, there's been a little bit of a mixed incentive there in terms of the state doing this. One of the nice things about the Affordable Care Act and the expansion of the population is because the money is provided by the federal government, suddenly you would believe that the state's interests are very well aligned to, in fact, suddenly go out and find people who are eligible and make sure that they do get enrolled. And furthermore, the individual mandate should help to reinforce to individuals out there, like, I think I heard the government said I need to have insurance. Good thing there's this government program that I can take full advantage of and be signed up and have that covered. Now, one of the things, just to get more directly back at your question, is that the Health Exchange in California has gone out and, in fact, invested something like $350 million in a state-of-the-art IT system to, in fact, create a front end that will be working to try to create a simple way for people to know about their eligibility for different programs. But there are critical questions that I think are embedded in your question. We know, for example, that probably about 40% of the individuals who will gain insurance coverage are of Latino backgrounds, and so there's likely to be some language barriers that could come up for individuals or people in communities that do not have access to the kinds of mainstream media that the general public relies on. So we're going to need to be very clever about how we, in fact, do outreach to populations to make sure that they are getting the benefit of that. And technology can certainly be a bridge to that, but we also have to be careful that because we have a computer system out there, we don't just sort of think that everything is okay. And then I'll just say one other aspect. So you're also saying, gee, how do we make technology be the solution and not the problem? And if I knew the answer to that, obviously I would give it, but I think what's embedded in your question is that so much of our innovation, which has been fantastic for improving quality of life and longevity and so forth, has also been a major cost driver in our health system, that we somehow have lost the incentive structure that seemed to work so well in the polio vaccine, right? We invent a polio vaccine, it's a tremendous technology, and by the way, we eliminate a disease and we save all this money. And we just haven't had that many technologies that are as successful as that. We seem to invent a lot of things and it adds cost on top of previous costs, whether that's in the area of imaging, whether that's in the area of prescription drug use and so forth. We clearly need to have a different set of incentives that make it in the interest to both be innovative but also to reward people disseminating those things in a way that in fact is cost effective. But I certainly welcome other people's thoughts about how we do that.
So, well, I'd like to thank the presenters because they obviously had 2 sets of speeches to give today and chose the right one to give. And but in the realm of Andy and Josh's comments about rolling up our sleeves and what can we do now in the UC system, Is there something that we're at a crossroads that we can come together as a consortium in a way to deliver to the state, being one of the 5 of the 22 public hospitals? And secondly, is there an experience that we can learn from in Massachusetts in the way that the academic medical centers perhaps came together and resolved some of their problems?
Well, I think it's an excellent point, and not something we've necessarily done particularly well as a UC system before. But I would think the key elements where we could collectively make a major contribution would be 1, access, and 2 is cost containment. And that means proposals that involve the workforce, legislative and regulatory changes, and delivery system reform or delivery system innovation that achieve one of those 2 goals. That's my, sounds like a pie in the sky answer, but I think those are really the places where we would need to focus.
I also think we have to have courage about, you know, what the new world will look like. I mean, getting a message yesterday from the court about that this is, you know, should take some uncertainty out about implementing this law. Right now, most hospital delivery systems, including UCSF, are primarily driven still on a fee-for-service payment model. Some of the changes become more possible as we imagine and implement different payment models that give us you know, fixed amount of money to take care of the population and incentivize us to focus on prevention and moving patients into the community rather than focusing always on bringing them into the hospital. I mean, there's a fine balance there, and I think it takes courage and leadership to know when it's time to make that transition. UCSF has been a phenomenal institution and has provides both incredibly high quality care at the, you know, the highest level of need and in terms of complex care, but a lot of that is fueled by a certain payment model in some ways, and so we need to be clever and courageous about how we in fact make that transition. And you referenced Massachusetts, and in fact I think the hospitals there have struggled with some of the same issues, but have, you know, started to move a little further out on that ledge, if you will, and to make that change. And I think those are some of the discussions I'm sure that are underway here about how do we do this in a way that preserves what we've been able to do so well, but also recognizes the future and where we're trying to go.
Okay. If I could just add, I think a real problem here is getting information out. Jamie talked about how the federal government essentially is going to be, on a sliding scale, providing supplemental money for getting health insurance. When you hear debates, most people, most sort of average Americans making $20,000, $30,000, $40,000, $50,000 think that they're going to have to go out and buy insurance at the rates that they now think of it. And there's really a terrific need for getting the information out. I was listening to Talk of the Nation yesterday, and there was a guy who was 27 years old. He was a part-time janitor making, $22,000 a year. And they asked him, and it was sort of a nice moment, they said, "Are you going to go out now and buy insurance?" And he said, "Well, I'm healthy, so I'm sort of that group that is sort of supporting the older Americans, but I'm patriotic, and I think that it is my responsibility, and when I'm older, there'll be younger people that will be supporting me." But it was clear within his question that he thought he was going to be spending a lot of money to buy insurance, or he's going to have to pay a tax penalty. And so there might be, just sort of on the front lines, you all are seeing the people today, day in and day out, coming to the hospitals, coming to see the primary care at several levels, getting some simple information. This is a brochure that says, this is what the Affordable Care Act does for you. This is the way insurance works. And I just haven't seen any kind of real push to get the information out to blue-collar average Americans who don't watch Talk of the Nation, don't go to panels like this, but you all are seeing day in and day out in your clinics, and they have absolutely no idea. They think that it's going to cost them a great deal of money. Jonathan Gruber has a comic book on that, which is very good. and it needs to be distributed in every office in California, and we should be leading on that.
So I just want to mention that we do have 2 microphones. If you have a question, put your hand up high, and as we're passing around, I'm going to ask Jamie, you put up a map of the states that show different rates of uptake for the exchanges, and we've been talking a little bit about California, the challenges here, but which states have been slow to move on implementing this, and which states are really going to be in the most trouble now that the act has been really completely upheld?
Well, if you go back to that slide, it will tell you, but there's been 6 states that really haven't done much of anything. And you can see there's sort of the light blue states with Idaho, North Dakota, Louisiana, South Carolina, and Ohio, and they have not started at all on the exchanges. And I think they will face the decision of, whether to just sit there and cross their fingers and hope that the federal government, that the act will be repealed, or they will face and accept the fact that the federal government will run the exchange in their state and may not be exactly what they want, but perhaps they can just take that on a political line. But I also think the 12 states that really waited and halted all of their planning, waiting on the Supreme Court decision, are going to have a really hard time. I mean, we've listened to Andy talk about the enormous effort that has gone on in California to get this up and running and how difficult it has been to do that. I mean, California certainly leads the way in the development of the exchanges. So anybody that hasn't started or has only kind of started, I think, is going to have a hard time following along.
Question up here, and then
there was a mention of the idea that there could be litigation against HHS regulation as a next step. I wonder if you think the proposed strategy of having the states define essential health benefits in the next couple of years is a way to mitigate that risk, and do you think that this strategy might be expanded beyond the next couple of years to keep litigation as a risk lower in terms of defining the essential health benefits package?
Yes, so I think that the attempt to give states much more flexibility in how they define the essential health benefits was definitely an attempt to restrain legislation and litigation on that realm. But I do think that to the extent that any restrictions are put on how that's defined by the states, I think that we could, you could be exposed to litigation risk or chances for states to try and fight on it, for sure.
Particularly with the Medi-Cal programs. Right now, they are absolutely swamped underwater, doing everything they can to prevent anybody else getting into Medi-Cal. How do you see this being affected or changed with this new regulation or laws?
I'm not sure if people caught that question. It's already difficult to get onto the rolls of Medi-Cal, and how might this legislation impact that? Is it going to make it better, or by encouraging lots of other folks to apply, could it actually exacerbate things and make it worse?
Before you answer, I want to actually amplify how big a problem that is, because in addition to the simply gaining roles, getting onto the rolls of Medi-Cal, the state of California is in a fairly rapid transition from fee-for-service Medi-Cal to regionally based managed Medi-Cal. So the San Francisco examples are the San Francisco Health Plan and Anthem Blue Cross, who provide a managed Medi-Cal plan, which the data suggests probably does a better job providing care, but is a much more complicated organizational structure. And so if you now add 5, 3, 4 million people to the Medi-Cal rolls, that will clearly overwhelm those programs' ability to function normally.
Yeah, one aspect of this that people have really worried about is right now eligibility for the Medi-Cal program is handled at the county level, and there's a lot of state workers who are involved in that process on behalf of the Medi-Cal program. I think one of the things that could change fairly dramatically because of the involvement of the exchange and its investment in this IT that we've referenced a little bit, that there may be, in fact, a much cleaner front end to the entry into getting health insurance that may, in fact, decrease some of the personnel needs to actually accomplish this. That isn't to say it would all go away, but it might be akin to how your experience has changed at the airport, where you used to all stand in the same line with your suitcase, whether you had one or not, to check in. And now many people can, use kiosks and other kinds of ways that can speed up the process. So there would still be some support personnel to help this, but probably by relying on technology can imagine a more efficient way of handling it. But Josh is also right that even once you're enrolled in the program, there will be additional decisions in many cases you'll have to make because California has really moved fairly aggressively into using managed care as its delivery system for the Medi-Cal program. It's historically done very well with that for low-income children and parents, but now are increasingly having the disabled populations move into managed care and is getting ready to experiment with having dual eligibles, those dually supported by the Medicare and the Medicaid program, into managed care as well. And so we're going to need to learn and pay careful attention to whether these managed care plans are able to provide the level of service, the adequate networks to take care of people with much higher levels of need than have historically been in the Medicaid managed care programs.
Well, one of the things I was going to say is that there are huge incentives in the bill to get as many people enrolled in the Medicaid program on January 1 of 2014 as possible, right? Because every day that they delay, you're leaving federal money on the table. So I know that organizations that are reaching out to those communities are really trying to get as many people signed up in advance. So on January 1 of 2014, those people will go on the rolls immediately. And so I think there's a huge financial incentive for the state of California to really push through on that.
Another question here.
I don't want to talk about broccoli. I do want to talk about a different vegetable, pizza. The fact is that the ACA was predicated on the notion that we'd be able to recoup costs by providing preventative services over time. That's a canard. The bottom line is we spend $147 billion a year on chronic metabolic disease, and that number is predicted to go up to $192 billion by 2020. We're now putting 32 million sick people on the rolls, many of whom have chronic metabolic disease, and other countries that have preventative services have not shown any reduction in their rates despite having those services. So the question is, where is the money going to come from, and where will it ultimately be siphoned off over the course of the next decade as these changes get rolled out?
Well, I just want to comment on one. I'm not going to completely answer your question, but I want to acknowledge something you said, which actually came up very clearly in the debate within Congress when it was dealing with this law. So, the process of passing a law in the Congress requires that any drafted legislation go over to the Congressional Budget Office, which is seen as kind of the referee for Congress. It's a nonpartisan group of economists that do very sophisticated modeling of both the current costs of things as well as behavioral changes that may come about as a result of policies, and really tries to estimate as best they can. It's really like futuristic stuff, and sometimes they nail it and sometimes they have trouble. But the more key issue here is that several provisions were written related to prevention with this very much in mind, that, gee, if we do prevention, maybe we can save money. And in fact, almost unanimously, the Congressional Budget Office came back with the answer of, well, we've reviewed the literature, and it's our belief that you can spend money on prevention, but the evidence base for how much that would save downstream is really quite poor. And this was, in some ways, it may reflect reality. It may also reflect the nature of that we do not have enough evidence that we've done in the areas of prevention that have really been successful to be money savers. And so while there were many people advocating for the philosophy of more prevention and wellness and so forth, and you see elements of that in the bill, when it came to the test of the referees and the economists, they agree with what you're saying. At this point, there is not a sufficient evidence base for many of the preventive concepts in there. And it actually, to me, was a call to action, and I share it back out to all of you that believe in prevention, that we need to bring the level of evidence gathering that we do in other forms of clinical trials, for medications and procedures and so forth, to the area of prevention. It's a wonderful philosophy. I think many of us believe that this is a good way to go, but there has not been the evidence base yet in place to really support this as a policy lever. So it's probably part of our solution, but figuring out which parts of it still need, I think, to be determined.
I think and I know there's some questions up here, so if you do have questions, put your hands up. Another interesting thing, when the ruling came out yesterday and I saw that Roberts has actually joined the majority, I was not as surprised. It might have been because David and Andy both told me that Roberts was going to join the majority and it was going to pass. So I wasn't as shocked as I might have been. But it did give me this feeling of, well, this says something different about the politics in our country that may actually be something quite interesting. If you look at historically, the big policy changes that have improved people's welfare in this country, they've been universal policies, Medicare, Social Security, that have sort of lifted all boats. And healthcare has never been in that group. And one of the questions is this ruling sort of an indication that maybe healthcare is moving into that sort of realm of lifting everyone's boats and really addressing population issues? Because that's what the question really is about. Is this really about health insurance and our healthcare system, or is this really about improving health? And I think that it's interesting to think about the kinds of questions Andy's raised and the ways that we need to think about these issues more broadly, not just in terms of the research we do in the sort of medical model, but in a population model. What does it mean if this is really a different way that we think about the health of our fellow Americans and sort of our own stake in each other's health?
Well, on that, I don't think we're having a very healthy debate. I think that we need more evidence-based politics. And when you hear, and it's candidates on both sides, but I tend to blame the Republicans somewhat more. I think that they simply distort the record, and they make allegations and claims, and it's hard to have that healthy debate. Now, if you study Social Security and Medicare, Medicaid in the 60s, there was a vehement debate, and there were certainly questions raised, but it wasn't at the level of polarization that we see today, and I don't think that it's at the level of distortion that we see today. And whether we can get back to that more civil discourse, I don't know. But I think that it's hard to make the argument until, part of the problem, in all honesty, with this bill, and I don't blame Andy for this, but the fact that it's being implemented, in 2014, that's a bad thing. People don't see, it doesn't resonate for them as to why this is a good thing for them individually. It's a good thing for their families. The parts that have been implemented, they do recognize that. Kids that are up to 26 now have health insurance. The idea of pre-existing conditions, I think, is starting to resonate. But a lot of this was put off, and it's easy to, again, distort the record if you don't have any evidence because you don't have implementation. And so right now, when you look at the debt ceiling issue, and we're going to face this again, this is going to be a very ugly political season, and there are going to be a lot of things said. And so again, it's a call to all of us to step up and help educate, to do local media, to talk to people, to get out and talk to civics groups, because I think that people need to have sort of a civilized voice coming through the din in these contexts.
I'd like to add, I don't often play the cynic, but I think in some respects, I would like to believe, Dan, that this is, there is some kind of turning and that people are really starting to care more about one another. I think that is true for some portions of our population. I don't think it's universally true. I think that there is a shared sense of pain in paying for health care that has started to affect a huge portion of our economy, and that is actually maybe what's driving this and making it more obvious for a lot more people. I think that our businesses are suffering under the weight of healthcare costs. Small businesses don't provide it to anybody. We're starting to see that this is not just taking a toll on people who can't afford health insurance, it's taking a toll on our overall economy as a whole and the ability of us as a nation to function and compete in a global marketplace. That is happening with healthcare too, and I think in some ways that is really driving maybe some sense of unity on this issue.
Hi, I was very pleased with Josh's comment regarding scope of practice and all practicing towards the top of the license. And I would echo that not only for those that are licensed, but also for more thoughtful use of non-clinicians, the kind of work that Tom Bodenheimer and others are doing with health coaches. But my question to all of you, to what degree are the various interest groups that have a stake in this embracing that position? And if not, what, if anything, can we as the UCSF community do to influence that?
Well, I'll take a first stab. A couple things that are happening that Andy referred to earlier about courage around delivery system reform are actually happening despite health reform legislation. And thankfully it isn't despite a change, but we're happening ahead of it. And I can give you an example of something that at least brings some of the parties, not all the stakeholders, together. So both in Sacramento and now in San Francisco, there was a large either employer or union that went to its primary insurer and said, you have 1 year to cut your rates, or we are taking all of our insured to your competitor. And it's a competitor that never gives them back, by the way. And this galvanized otherwise completely disparate parties, meaning the hospitals and the doctors and the insurers, all came together in the plate to try to preserve their ability to care for a population. And it has begun to loosen some of those things. They're not all related to scope of practice, but some of them are. So I would say that in a few examples, we've seen a little bit of ability to affect this. I don't know at a legislative level or when you look at sort of professional societies, you know, maybe not so much.
A quick micro question for Andy, and then a more complicated macro one to Jamie and David. Andy, under the current formula, people on the state Medi-Cal program get 50 cents on the dollar from the feds, 50 cents from the state. In 2014, do they get the same payment ratio? Okay,
yep.
Thank you.
So there is a mechanism that traditional people have the same reimbursement from the state, but it's the new category that will be the 100% for the first 3 years and then tapering down. It's recognized that it may be complex for the state to kind of figure out, would this person have qualified under the old rules or will they qualify? And so there's actually a regulation moving through that will give guidance to states about how they may, in fact, be able to sort of blend that all together and kind of decrease some of the administrative complexity. But in theory, what you said is exactly right. The old people get the old rate, the new people will get the new rate.
But in 2014, the old people get the new rate too.
No, that's what I'm trying to say. The old people stay at the old rate. And this is actually, okay, let me just actually take a moment. This is critical for understanding some of why the states are a bit frustrated with the federal government. It's been referred to sometimes as the woodwork effect. And so when I referenced earlier that there are people who are eligible but not enrolled, by making an individual mandate, a parent of a low-income child who may not have signed up previously for Medi-Cal, but now because of the mandate does, they're not a new eligible. They're actually someone who's, they are new eligible to you and me of understanding, oh, they're new in the program, but they are qualifying under the old rules of eligibility, and so that the state is only entitled to 50 cents on the dollar.
Okay, that is really complicated. Opposition to the ACA has been a galvanizing theme for the Republican Party, and it is conceivable that it could carry them to the presidency, the Senate, and the Congress, the House. If that happens, you're the prophet, you know about it. What will be the strategy to unravel this?
Professor.
Well, you kind of predicted the 5-4 ruling, so
yeah.
What's going to be their strategy in 2013?
Their strategy will be first, as you say, to win the White House. Second, to win the Senate. They do not actually, because it was upheld as a tax provision, they actually will not have to worry about a filibuster. So the ACA was passed actually is a cost measure, and so therefore is filibuster-proof, because when they lost Ted Kennedy and they lost Massachusetts, the Republicans could have filibustered it, and so on the theory of what goes around comes around, the Republicans plan to do exactly the same thing. So if they have the House, they have the Senate, and they only need 51 in the Senate, they will try to repeal it. And so far as I know, procedurally, and Andy may have a follow-up on this, procedurally there's not much the Democrats could do about that. And so I think that get out and vote. I think that the actual machinations in the Senate, there may be some procedural obstacles that can be thrown into the way. As Jamie mentioned, and she may want to follow up on, there are a lot of provisions that the Republicans don't want to get rid of. Whatever they say now, they're not going to get rid of it. So even if they were to repeal it, they're going to have to repeal it in piecemeal fashion, and that itself might present procedural ways for the Democrats to step up and make deals on the provisions that they want to keep. It's really the individual mandate that has made people see red. But they lost the first battle. They lost the constitutional battle. Now they want to frame it as a tax issue. It was always a tax issue in terms of being obligated to pay either to buy insurance or to pay the IRS for failure to buy insurance. That always existed, but there will be some effort to take advantage of the rhetoric of raising taxes. Of course, Romney has some difficulty with that because the Massachusetts plan did exactly the same thing. So to the extent that he's accusing Obama of, quote, raising taxes, and it's not clear how this would be raising taxes because you're actually getting a good for what you're doing instead of paying a tax bill, but Romney's in exactly the same position. So he doesn't have clean hands in that regard. So it's going to be a mess, but I think that we ought to do everything we can to ensure that one of the two branches or one of the two houses in Congress remain in Democratic hands.
Yes. No, I think that if they get the House and the Senate and the White House, I think this bill will be gone. And I think it will be, I mean, it is what Romney is running on. It is, you know, if you looked, you just typed in Mitt Romney, there'll be 10,000 pictures of him and saying repeal, 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 which is so incredibly ironic. But I think that they will do everything. I think they will repeal the whole act and then potentially try and put back the things that they like or as part of maybe a larger bill. Or they might just leave healthcare out there to dangle. I think that there will be some pressure on them to put something back in. It will not be nearly as comprehensive. So yeah, I agree with David. To the extent that you like this bill and you want to keep it and you want to see it stick around, as much education of everybody as you could possibly find about how it is going to benefit them, I think is really critical. A lot of the polling data shows that people they just don't understand it. They don't understand how it applies to them. They don't understand that they're already paying for the uninsured. It's not that we're adding an additional amount. Like very, very intelligent people do not understand that we're already covering care for a lot of individuals and through uncompensated care. And so to the extent that we can get the message out about how this works, and that people aren't going to be paying, you know, thousands and thousands and thousands of dollars that they really can't afford, I think is going to be very important.
H.L. Mencken said about democracy, the theory of democracy, that the people get what they want and they get it good and hard. So I defer to H.L. Mencken on this.
Well, just for Andy, we actually have quantified the health cost savings associated with tobacco control, and you get a 50-to-1 return on investment, and very quickly. So we've even published it and stuff. So you can give that to the people in Congress.
It actually showed up in the bill.
Huh?
So you may not be aware, but it actually showed up in the law. So that was one of the small areas that the CBO did actually say prevention worked, and as a result, Medicaid programs across the country which did not cover smoking cessation strategies, it is now part of a defined benefit within Medicaid that they have to cover those treatments. And so, in fact, it was I can't remember how many hundreds of millions of dollars were estimated, but that was actually one of the few areas of prevention that came out as a cost saver.
Yeah, well, anyway, but my question, that was my comment. Now, the question I have, to the two lawyers, I mean, you mentioned that, you know, that there can be a kind of rearguard litigation action against the implementing regulations. And I would just like to hear a little more about that. And because it seems that right now you have this situation where now that the Supreme Court has acted, the sort of de facto position is to move forward. And you have the hospitals and the health insurance companies and a lot of state governments. And so at one level, it would seem that there may be a lot of important interests that maybe didn't love the bill, but were continuing to gum up the gears is actually going to cause a lot of trouble for them. But on the other hand, you know, anybody can file a lawsuit, and there are wealthy interests that are going to fight this to the death. So I was just wondering, I mean, how do you see that, you know, playing out? How do you see the courts intervening if someone goes in asking for temporary injunctions and things like that? I mean, could you, since you predicted the outcome so brilliantly, I mean, could you sort of tell us a little about kind of how you think that would happen and how you think the courts would deal with it and how the various interests that are involved would react?
Jamie actually might be the better prophet on this issue. As a constitutional matter, this litigation is dead. There are no constitutional issues left. They were all settled in the ACA case. But you know, after Brown versus Board of Education, it took decades and decades, and even today, you could say that Brown has not been fully implemented. So the court might decide a case, and then there might be vexatious litigation and simply not abiding by the law, and then having to drag them in the court to force them. There's a lot that needs to be done under the Act in terms of regulatory development and public comment, and so there are a lot of choice points where litigation could pop up, where people fail to act because they refuse to act, and you have to bring a cause of action to force their hand. So there are lots of things that, in terms of implementation, because there are so many moving parts to the Act, but they're not constitutional, so I don't need to worry about them. But there is certainly the potential for a great deal of litigation, I think.
Well, one of the areas of litigation that is likely to come up is sort of contraception coverage and who has to provide it and where does it come out and what do they have to cover, and that might actually get into your constitutional realm.
I stand corrected.
But yeah, I think those are the kinds of things that you're likely to see pop up. You know, we don't want to cover, you know, people litigating different parts of the minimum essential benefits plans, people litigating different things that are required for, I don't know, a whole host of things. I think the essential benefits plans are going to be one of the things where we really see litigation on a number of different fronts, and you know, people love to litigate abortion and contraception.
But with that, I mean, people love to litigate.
Right.
But do you think that the fact of the litigation
is good? No, I don't. I don't think so. I think that. I think what will really cause implementation to go forward full steam is after the election. Once we know, there are still a lot of states and still a lot of people who are saying, okay, we lost or we won, however, you know, wherever you are, the Supreme Court battle, and now we're still not going to do anything until we see what happens there. So once that goes forward, I don't think little fights at the state level about how to, you know, how this is going to go forward is going to gum up anything going forward, really, as on the overarching bill as a whole.
And by the way, I do predict that the Democrats keep the Senate.
I feel so much better.
You heard it here first. So we have a question up at the top, and then maybe we can get a microphone here.
Yeah, I have a question about whether anyone is really going to say the emperor has no clothes. And this is because it's pretty well established that a large part of health insurance premiums are the administrative overhead costs. 40 years ago, administrative overhead costs were 5 to 10%. Now they're 40, 45%. As a matter of fact, the insurance industry has a term called medical care loss ratio, which means every dollar they spend on medical care is considered a loss. This is their philosophy. Now, the ACA does have a provision for capping that, but everyone I've talked to says, oh yeah, they'll get around it, they'll do creative financing. Is there any chance that people will say, no, you will not do creative financing, that you will return, to the payers the healthcare services that you're supposed to provide?
So, you're clearly very knowledgeable about this topic. The medical loss ratio, which is that concept of how much of the dollar is going for the patient versus administrative running of programs, is set at 80% for health plans in the law. I hear what you're saying about are there going to be ways to work around that. One of the things that happened in Massachusetts, which again is sort of the basis of the federal law, was that subsequent state legislation gave enhanced powers to the state insurance commissioner to really have clout in negotiating potential pay increases that or premium increases that were being asked of by the health insurance companies in that state. And in fact, there's been pretty significant pushback there. You may be aware that the state health insurance commissioner here, Dave Jones, has also been very actively pushing for California to have that as well. And I believe there's going to be a ballot initiative in the next election that will give Californians the chance to decide if they want to give that level of power to the state health insurance commissioner. So I think it's a really important issue. It's complicated because some of the things that get buried in those administrative costs may in fact offer value. So it could be some things like care management or the capacity to use information technology and electronic health records to monitor populations. So it's not a direct service to an individual patient, but is happening more on a population level. And we just don't have fantastic accounting mechanisms to sort of say, that's a wasted administrative dollar, that's a well-invested one. But I do believe at least ACA has set some standard for the first time of at least saying, hey, we care about this issue. We're not looking for just endless profits coming out of these health plans and going into investors' pockets and so forth. But look, it would have been fantastic to have had additional things like, public health plans as a way that might have been able to keep administrative costs lower. I think you're probably familiar and others are familiar with the fact that the Medicare program, which covers so many people and the elderly in this country, actually keeps its administrative costs extremely low. And for many people, that would have been a fantastic model to have spread from. But if you recall, the debate in Congress just did not allow itself to get 60 votes in the Senate and to have a public insurance plan. And so, unfortunately, we don't have that today.
I actually wanted to just follow up briefly and get to time for a couple more questions and ask Josh, because when we were talking about the politics of repeal, when ACA passed, there were a lot of hospitals and payers who were supporting it, and they see the need, as Jamie mentioned, to relieve the burden of costs on their organizations and their business. I got an email from an IHPS colleague last night saying this is who's in favor of single payer, who does not see this as good news at all, and sort of wished that ACA had gone down, because then there would have been a chance to build it up the right way and addressed a lot of these issues. So I guess my question, Josh, to see if you want to take a swat at is, from the perspective of providers, what does this look like, and how scary would it be if after the election there was an appeal attempt made? What are the politics there? Because it seems to be going both ways.
Sorry, do you mean if there were a repeal attempt that was successful?
Or even if one was mounted, are the politics going to shift, or are the hospitals and the providers still going to feel we need this?
All right.
If we're going to, I'm
going to take a random hack at that then, because my guess is that the hospital industry will remain supportive, because the big picture is more people with insurance has value to hospitals. Whether the insurance industry will remain supportive, I wouldn't even hazard a guess. But I do think the American Hospital Association will continue to be supportive, even with a repeal attempt.
And to follow up on that, but with providers, I mean, it's awfully hard right now to find physicians who are going to take Medi-Cal. You know, and now this is expanding. How are we going to find people to treat these patients? And the other question that I have is about the costs of this. You know, and I'd be interested, Andy, if you feel the initial reports by the CBO that this would not cost money are still valid. Because as we're trying to educate voters, that's one of the big concerns, that, yeah, this is nice, but it's going to be unbelievably expensive. And on the part of providers, and I'm involved with a lot of professional organizations, you know, a lot of them are saying, well, this isn't going to affect us. We're not going to see these patients anyhow. I mean, we just can't afford to do that with all of the debts that, you know, people get out of residency with, and they're not accepting Medi-Cal. So unless they're forced to do it, which is a whole other level, that's another set of problems. But I wonder if you'd comment on both of those things.
Well, one thing I want to point out that, you know, we are all appropriately very worried about the cost of health care, but it's not an incredibly widespread a bit of information that, in fact, the last few years, we've actually starting to see a fairly dramatic slowing in the growth of healthcare costs. And it isn't to say that it's at the level that we would ideally want it to be, but there is something starting to change. And, you know, maybe it's that when you pass a law like this that people start to, in fact, saying, well, actually, we could have been doing this thing, or and so forth. So there may be something happening, and the pressures that we heard about, the pushback from large employers and unions and so forth, saying, hey, we can't just, you know, keep doing this, because we still want to have education systems and other kinds of public services. It can't all become consumed with health care. So I do think that something has started to happen. It's early on, and people are trying to sort of read the tea leaves of what's actually driving that. But there has been a fairly significant slowing of how much the Medicare program and growth of healthcare costs is where it's going right now. Now, in terms of Medi-Cal providers, I think, again, some of this will be very state-specific. I pointed out, I think California currently has the 47th lowest provider payment rate of all of the states, which has a big impact on physicians' willingness to participate. And I've seen recent research to suggest that California has the second lowest rate of physician participation in the Medicaid program of any state Medicaid program around the country. And there's probably a couple of different reasons why that's going on. A big one is clearly the payment rates, which are set by the state. And you may know that the state continues to be in court arguing to, in fact, lower provider payment rates, which I think really could undermine the ability to expand access in the way that we talked about earlier. We do have, as a delivery system, we do have a tremendous safety net structure. We've talked about the public hospitals, the UC systems, the clinics, and so forth. And in some cases, that may give an easy way out, if you will, for everyone to participate in this game. You know, one of the things I love about the individual mandate is that it does sort of level the playing field on the patient side. We don't have an equivalent of that on the provider side, of how do we level the playing field to make sure that all providers contribute in some fair share way to what is, you know, is needed. And that would be, I think, a fantastic issue for the profession and providers to take up in some way, which is to say, look, we know some providers will take on disproportionate amounts, but everyone should give something, because this is a societal issue that we should all face up to.
I would answer your question slightly differently, Renee, and that is, in the intermediate and long term, preservation of the fundamental system of care being provided in an office visit or in a hospital, if we continue that model, we will fail to reach our goal of cost reduction. So there must be fundamental innovation in the way care is delivered that can't simply just try to preserve the way we're doing it now with a little extra cash.
Maybe we'll do one last quick question, if it's a fast one. And
I'm representing the elderly. Is this going to affect Medicare, and if so, how?
Great question.
I have no idea how it's going to affect Medicare.
Well, I think there are certainly many provisions in the law that address specifically things in Medicare, and some of them are, in fact, Dr. Adler talked about earlier. There's a lot of investment in innovation to try to change the delivery model. There's a lot of investment in changing the payment model for Medicare beneficiaries so that there are more bundled payments and so forth. Something that we didn't talk at all about today, but that you probably read about in the news from time to time is, these automatic cuts that are supposed to kick in for providers, for physicians to get a dramatic decrease in how much they're paid by the Medicare program that the Congress has continued to bail out but has never made a permanent fix to. So there's no question that the Medicare program will be scrutinized and to look for finding more efficiency in the ways that were just referenced that we have to do in general throughout our healthcare system. I think it is recognized that the elderly are, very important group as a voting group, and in terms of a program that is generally rated as the best running health insurance program around. And so I think there'll be great care taken to try to preserve that while also trying to find some financing efficiency. But we also read about at the same time our federal deficit and so forth. So there's no question that Medicare is a large component of that will undergo scrutiny. But how the specifics of that play out and how effective we can be at taking out waste while leaving all the good aspects is, I think, the details ahead of an implementation.
We have 1 minute left. I'd actually like to take this to thank our panel. They had an incredibly difficult task. They got the opinion yesterday at 7 a.m., actually 7:14 a.m. And I know they've been very busy gathering their thoughts. So thank you all very much, and thank you all for your questions and engagement.